Back on the right stand with the debate over same-sex marriage, which is only getting bigger. Now the Bar Council of India has unanimously resolved to request the Supreme Court to leave the issue of same-sex marriage to the legislative process for widespread consultation. The Bar Council of India has said that marriage is a union of biological man and woman, and it would be catastrophic to overhaul concepts of marriage by any court. When adoption, inheritance, marriage, birth, death are not the remit of the Honorable Supreme Court as per the Chief Justice of India, and that it is the remit of the legislature, how can the issue of inserting or considering same-sex marriage, that too not across all ambits of marriage but only under the Special Marriages Act, be the remit of the Honorable Supreme Court of the country with a 5-judge bench? This is a question many people are asking, and is this a case of judicial overreach? Also, the Chief Justice's observations have caused quite a furor, that in the guise of observations, can you actually make comments that you have done, and does that actually befit the seat of the Chief Justice, chair of the Chief Justice? Interestingly, filmmaker Vivek Ranjan Agnihotri, who's made Kashmir Files, who's made Vaccine War and is working on Delhi Files, has put out a very interesting tweet that's got a lot of traction and perhaps will echo with a lot of people across the board. He says 10 important questions on the 5-judge bench on same-sex. So that's where he starts, 5-judge bench on same-sex marriage. And he says, with utmost respect for the judges and the judiciary, not questioning their competence, merits of families, I have some humble observations about a potential conflict of interest. He says, as per the available information on the net, all 5 judges are upper caste and privileged. There is no representation from the SC, ST or other oppressed class. All of them are UC Hindus or upper caste Hindus. No representation from Muslims, Christians, Jains, Sikhs, Parsis, etc. No representation from marginalized, discriminated LGBTQ++ category. Okay, is it possible for this group of judges, privileged Hindu only bench, to change constitution and destiny of a nation without any representation from marginalized communities? If the Chief Justice of India observed that sex is not absolute and one can identify as either man or woman, then shouldn't it be mandatory for all the esteemed judges to declare whom do they identify as? For I don't know if the arguments, observations, judgments are being made by a man or woman. This is what he is turning around and saying. Let's scroll down a little and look at points 5 and 6. We'll take that further. Let's look at point 5 downwards. What does he say? He says, I'm sure all esteemed judges are academically and professionally super qualified, but in a diverse country like ours, are these UC privileged Hindus whose gender identification is unknown, are they culturally, psychologically, civilizationally and spiritually equipped to re-engineer world's oldest society? I understand that even the counsel arguing in the case are mostly upper class privileged Hindus. None of them have identified their gender. So plenty of observations and plenty of questions there. Going straight across to Shashank Shekhar Jha and Nikhil Mehra joining us at this point. Namaste, Jai Hind. Thank you very much, gentlemen. Where do you stand, Shashank ji? Do you identify with the concerns raised by Vivek Ranjan Agnihotri? Is this a remit of the top court or should it be left to the legislature?
Namaste. I think this is a very clear observation, and the questions which has been raised by Vivek Ranjan Agnihotri is being bound to be asked by every citizen of this country. Now, Supreme Court is dealing with a question which will regulate or change the future of 140 crore population of this country. So definitely such questions will arise, especially in a country where the society is divided among themselves in such a huge manner which is unseen or unparalleled. Whatever Bar Council of India has said today is also nothing which can be disputed. Even all those petitioners who have asked for same-sex recognition and declaration by the Supreme Court of India have actually said the same things, as in that not many are in their support, and that is why they have moved before the Supreme Court of India, because as per their own claim, Parliament is not taking up the matter. So I don't think there is any dispute in that. Now, as for a matter of record, all 5 judges are definitely coming from UC background. So that is also one thing which Mr. Agnihotri has pointed out. Now, how it will be taken up in future, I don't know. But yes, without questioning the competency of the honorable judges of the honorable Supreme Court, I think that all those questions must be asked, and that is
See,
why.
by large, the
when-
question has been, with due respect to the wisdom of the benches, can a group of men, 4, 5 individuals or 5 individuals, decide the fate of a country as diverse as Bharat with multiple rules and society? Especially when we don't have a common civil code. Until we have a common civil code, will there be continuously discrimination? Rights of one person be discriminated against the rights of another? Based on the judgment of a few, is that possible? Nikhil Mehra, where do you stand?
With a request 5 or 7 or 9 or 11, and they are trying to diversify what their particular membership is. But this is really, to be perfectly honest with you, Anand, a really pointless question. The constitution of the court is what it is. Questions keep arising at the moment at which they arise. Are we, for example, say that if ever have to make a decision on Article 3, there are no Kashmiris on the bench, therefore this is not a valid decision. This is just not how you look at the court. The court is always static. It has a certain membership and it has questions that are posed to it, and it must answer those questions.
Why?
I also do not agree that there is some massive re-engineering of society happening here. To be perfectly honest with you, the Parliament has had the opportunity to address this issue for quite some time. The first judgment on legality of homosexuality happened as far back as 2009. Then the issue of legalization was thrown back to Parliament by Supreme Court. Parliament again took no step. Eventually, a review had to be filed, and that review led to a striking down of 377 in relation to consensual practices. So Parliament repeatedly wants to take no steps whatsoever. So the issue the court is posed with is there a violation of fundamental rights? That is a core judicial function. Nobody can tell me that is not a question the court can. That is a question the court can answer.
But can the court
The court is
formulate
doing
law?
its job in that.
Can the court formulate law? And is the court right in saying,
In an
I'll
ideal-
set personal law aside, but I will look at it only under the construct of the Special Marriages Act? But that itself defeats the purpose of the court, which takes a position that the anything to do with the common civil code is not within the remit of the courts. It's with the legislature, because that's the exact words of the Chief Justice when it comes to divorce, when it comes to adoption, when it comes to laws on marriages, when it comes to laws on inheritance, that we need a common code so that it's not discriminatory against one or the other. And the court has come back and said, no, it's the remit of the legislature, Shashank Shekharjal. So in this case, if the Parliament is not ready, is Parliament not a reflection of society? Is society then at large ready? If society is not ready, and if you have not thought this through, then is this not going to lead to further discrimination?
This will definitely lead to further discrimination. See, Parliament represent people of this country, and that is why for particular seats there are reservation for those categories who are not otherwise being represented properly in this country. Before Supreme Court, there is no such provisions. And when these 5 judges are discussing over the same, you need to understand that they are trying to create a new law. They are trying to make space for homosexuals in a heterosexual law, thereby creating new laws, and which will ultimately disturb all other laws. For example, inheritance law, adoption law, custody rights, child rights, etc., etc. This is a country, we need to understand, this is a country where Islamic law permit marriage rights for women of over 15 years, which is not allowed for Hindu women. So how will you deal with that? This is a country where marriage rights is permissible for men over 21 and for women it is 18. How will you deal with that? So I think, just cherry picking particular things, and you are saying that you will only deal with special marriage act will ultimately, will go against the interest of all those who are actually petitioning this before the court.
Nikhil. Can you hear me, Nikhil? Now, at the end of the day, there are also observations. Shashank, in the past, the courts have said, I think we've lost me. Quickly, want to understand from you. The courts have said, don't take our observations as law or judgments. We have got the right to observe. But the nature of the observations, can they become controversial? can they become a huge matter of debate, or should one let it slide? Nikhil Mehra, when the Chief Justice himself sits there and talks about gender fluidity, then is that defeating the purpose altogether?
And I understand. Let me put this in two ways, right? First thing is when you said that they don't want to step into the domain of personal law. First and foremost, they have often stepped into the domain of personal law. Problem in India is that the legal position is such that they are often required to interpret ecclesiastical law, in fact. So on this occasion, they have stepped out of that domain to say that we are not redefining marriage there, but we may be able to define marriage in the context of a parliament-made law, which is a man-made law. Because what you do not want to do is for the Supreme Court to declare an additional interpretation or a meaning, and this clearly is that. Let's be crystal clear about it. The Special Marriage Act is passed from a gendered perspective. It is passed from a male-female perspective. And so this is an additional interpretation. And they don't want to impose that upon personal law. As to this second question that you've asked me, look, there is a slight danger that comes with this constant. One is the live streaming of proceedings, as well as this sort of live tweeting of proceedings. There are a lot of questions, a lot of throwaway observations that happen in these kinds of cases, where the judges tend to put positions to counsel so as to be able to test the entirety of the principle on the whole.
Right. We'll see how it pans out. I've run out of time. Before I wind this broadcast up, Shashank and Nikhil, thank you for your joining us. This calls for a larger conversation very soon.